So I'm here today to tell you about the Roe v. Wade abortion case. The Roe v. Wade abortion case is between Norma McCorvey and Henry Wade, who is the law chief enforcer of Dallas, Texas. Norma McCorvey was born in Dallas. She worked at a carnival selling tickets for an animal show in August 1969 in Augusta, Georgia. McCorvey never thought or talked about her feelings toward abortion until she came across her own problem with pregnancy. She's now sitting in a restaurant with her two lawyers, Sarah Weddington and Linda Coffey, telling them about her story about the night she was raped. It all started, she says, on one summer night when the carnival was closed. McCorvey and her friends decided to walk back after their shift was over. On the way, she says they were attacked and McCorvey was raped. She only remembers stumbling back to her motel room, finding her friends gone along with their things and hers. She didn't report the rape, though she thought about it. When she woke up the next morning, the carnival was gone and there was no scent to her name. She returned to Dallas, where she had friends and family. She stayed with a friend who had sent her money to get back. She found a job as a waitress when she suspected a problem. At first, the signs were very subtle. She wrote them off as symptoms of stress. She left her friends and moved from place to place. She had looked this way when she was pregnant with her first daughter, Years, who was now living with McCorvey's mother and stepfather because she couldn't support her. She went to see a physician who told her she was pregnant. She didn't know what to think. She couldn't even support her first daughter she had years ago. How could she support a baby now? So she asked about an abortion, even though it was illegal in Texas in 1969. But the physician refused. She thought the best thing was to have an illegal abortion since she didn't have the money to travel to a different state to have a legal abortion. Weeks passed and she couldn't find anything that she wanted. A friend suggested an adoption. So she asked for information from the physician and agreed to meet with a lawyer. This is how she met Linda Coffey and Sarah Weddington. They wanted McCorvey to sue the state for not allowing abortions. They told her they would do most of the talking in a 3-judge federal court. McCorvey wanted to do this. So as weeks passed by, they started making their abortion case. They realized court cases moved slowly and that McCorvey might not be able to get her abortion. They could, though, get a restraining order to allow other women to get abortions until their full case was heard. But another problem was McCorvey's background. She dropped out of high school. She married at 16. She had a baby whom she had to give up to her parents. She had problems with her family. She moved around a lot, and her brother was always getting into serious trouble. And there was the rape story from that night. McCorvey kept changing the story, so her lawyers did not know what to believe. She basically muddled up her life, and the lawyers were trying to figure out how it would not come up in court. They wanted McCorvey to become plaintiff in the case, but she would definitely have to have the baby. It was 4 months into the pregnancy by this time. No physician would probably want to perform an abortion because it would be considered murder. Coffey and Weddington didn't want McCorvey's rights to be jeopardized either, so they came up with an idea to give her a fake name to hide her true identity. This is how they settled on Jane Roe. They now had a solid case and believed that it could be done. Weddington knew all about abortions because she had to get one when she got pregnant in law school with her boyfriend. She had her abortion in Mexico, and she was one of the lucky ones. Along the case, the two decided on adding the 1st, 4th, 5th, 8th, 9th, and 14th Amendments. On Tuesday, March 3, 1970, Coffey took the Roe v. Wade and the Does v. Wade case to the federal courthouse. The suits asked that the Texas abortion statutes or laws be ruled unconstitutional and would prohibit Henry Wade, the chief law enforcement officer, from enforcing them. Word of the suit spread quickly, and soon news stories were nationwide. Henry Wade was served papers saying that Jane Roe was suing him. He appointed one of his lawyers, John Tooley, to defend the suit. The court combined both cases under the suit of Roe v. Wade. Tooley said that Roe had no right to sue because the abortion affected only persons who performed them. The next day, another party asked to intervene on the case, which is someone who seeks to join the lawsuit after it has already been started. Coffey and Weddington were excited to see that the intervened was a physician, James Halford, who performed an illegal abortion. When his lawyer, Roy Murrell, heard of the case, he called Coffey and suggested they joined forces. This was good because Coffey and Weddington had not found anyone from the medical profession to support their case. Now they had a stronger case and a greater chance of overturning the Texas abortion laws. Tooley filed a request to interview Jane Roe. He wanted to find out more background information, how far into the pregnancy she was, and if she was as poor as her lawyer said, because maybe she could afford to have the baby, maybe she just didn't want to. Coffey and Weddington began to worry. If the request was granted, this would be a disaster. But Roe was determined to stick out her case. Judge Hughes ruled against Tooley's request, and Jane had to testify under oath. Coffey and Weddington were successful in keeping McCorvey's true identity safe. Now they just had to wait and see what the court would do with the facts the two lawyers gave them. Tooley asked for a jury trial, while Coffey wanted the case to be decided on the basis of the facts without hearing additional evidence or having to call more witnesses. They wanted to keep McCorvey out of court so information wouldn't slip. The jury trial was denied, so obviously McCorvey and her two lawyers were happy. On May 23rd, Coffey and Weddington appeared before the Fifth Circuit Court of Dallas to present their arguments. Along the case, there were different opinions of abortions, but at the end, the state argued that destroying a fetus was just as bad as strangling a 3-month-old baby. One of the lawyers, Floyd, said that Jane Roe had either already had her baby by now or was due soon. Mary Doe was not pregnant, so she couldn't sue, which was another person on McCorvey's case. Tooley had a solid argument, asserting that the state had to balance the two rights of the fetus to survive versus that of the mother's privacy. Coffey and Weddington were afraid Tooley's argument had damaged their case. Then, to add on to their stress, another lawyer, Ivory Goldberg, asked one last question, which allowed Tooley to also score more points as well. Coffey and Weddington had goofed up by limiting the suit to only Henry Wade and not the whole state of Texas. On June 12, 1970, the Fifth Circuit Court issued its decision on the Roe v. Wade case. The findings and copies were put in mailboxes of two newspaper organizations. The decision was 13 pages long and stated that Jane Roe and Dr. Halford had the right to sue, but Mary and John Doe did not because Mary was not pregnant or involved, and she did not suffer any injury. So Texas abortion laws were unconstitutional and that a woman did not have a right to an abortion. The Fifth Circuit Court found the Texas abortion laws to be very unconstitutional because they are vague and exceptionally broad. The court failed to clarify when and how a physician might legally perform an abortion to save the mother's life. In the end, the plaintiffs won declaratory relief and relief from the constitutional laws, but failed to obtain injunctive relief, which would have prevented the state from enforcing the laws. The court could have declared the Texas laws unconstitutional. As law enforcement agencies around the state called the DA's office with their questions, Wade responded by saying that the law was still on the books. The state was appealing the decision of the court. No injunctions against the state had been issued by the federal court, and the DA would continue its efforts to prosecute Dr. Halford for performing an illegal abortion. The Dallas district and attorney refused to change state policy toward abortions. Now all Coffey and Weddington had to do was take their case to a higher court in hope of getting an injunction. The court failed to grant the injunction, appealing to the case where Jane Roe, Dr. Halford, and two litigants anonymously named the Does. Then Swartz and Pitts joined the suit of Roe v. Wade, which were two others. The Supreme Court said they would hear the case. While preparing, Coffey and Weddington received a call from Roy Lucas to offer his help to their case. Although Weddington was the one in charge of the case and had told the court the 9th and 14th Amendment supported a woman's right to receive an abortion, she also asked if the constitutional defense of the rights of a fetus had ever been decided in court. Weddington had done her homework and found the Thompson v. State case where the doctor was sued for an abortion contended the state was not able to prove that the fetus was alive and well at the time of the abortion. In order for an abortion to be considered murder, the existence of a body needs to be proven. The fetus could already be dead. Therefore, the abortion wouldn't be murder unless it was proven alive and healthy. Weddington had successfully argued that, and Floyd began his defense. Floyd had undid any good he had already done by being questioned and having not so good answers or none at all. The Supreme Court met December 16, 1971 to discuss the merits of the case. For working on the case for 2 years, Weddington was very disappointed when the court wanted to re-argue the case. She and Coffey, along with Brunner, Murrow, and lawyers of Dr. Halford, brought up new developments in the case. The case was argued, and they had a chance. All they could do was wait. On October 1972, the draft began circulating. By early December, the final draft was ready. Weddington and Coffey had won their abortion case. McCorvey says she felt if she helped millions of women across the world. But this was only the beginning of the controversy. There would be many more battles, but they won this one. This is a picture of the two lawyers, Sarah and Linda, after they had won their case. And these are signs that are being held up along the case. Thank you. That is all I have on the Roe v. Wade abortion case.